And then when it was again remanded to the trial court, and then Laila de Lima was acquitted once again. So twice acquitted in the same case. Never-ending cycle of filing of bogus charges or pursuit of a bogus charge, and we don't understand it. It's as Congressman Laila de Lima said, it's maddening because this is in fact in pursuit of the most expensive frame-up in Philippine history. So it doesn't make legal sense.
Enzo Recto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
The congresswoman calling this maddening. There have been other legal experts as well who have called it in similar terms. But from where you sit, how do you make sense of it? What sense do you make of the DOJ prosecutors seeking for a reversal of the acquittal? Attorney De Leon.
It's tough to answer your question because the question is, what sense do I make out of it? Because it doesn't make any legal sense. It's very explicit in the rules of procedure, of criminal procedure, that an acquittal is not subject to motion for reconsideration. But they've done that already before, and they in fact even elevated an acquittal to the Court of Appeals, unheard of in for us practitioners of criminal law. And then when it was again remanded to the trial court, and then Laila de Lima was acquitted once again. So twice acquitted in the same case. Again, they're filing for a motion for reconsideration, which again is prohibited by the rules. So this is a never-ending cycle of persecution, never-ending cycle of filing of bogus charges or pursuit of a bogus charge. And we don't understand it. It's as Congressman Laila de Lima said, it's maddening because this is in fact in pursuit of the most expensive frame-up in Philippine history. So it doesn't make legal sense. That's first. The second thing I just want to say is we have to remember that the panel of prosecutors is actually a representative of the people, number one, and number two, they're speaking for and behalf of the Department of Justice. So it's a little bit confusing because the Department of Justice already categorically stated through its own spokesperson, Asik Levano, that the decision of the Court of Appeals is not a reversal per se. And I'm quoting that, no. But the tenor of the motion for reconsideration seeks for the full reversal of the acquittal. So is the Department of Justice actually still in control of this panel of prosecutors, or is the stand of the Department of Justice, is it their stand to continue weaponizing the justice system against dissenters of the Dutertes? No. So if that is not the official stand of the Department of Justice and the official stand of the Marcos administration, is the panel of prosecutors still under their control? Was the motion for reconsideration given the go signal by the Secretary of Justice and by the Department and by the Marcos administration? That confuses us as well.
As you were pointing out earlier, Attorney De Leon, there's such a thing as, it's double jeopardy, and now, in so many words, and now we're seeing something that's unheard of. People have said, what is this? Is this triple jeopardy? It's unheard of, maddening, as the Congresswoman said. But let me ask you this. Did this come to you overnight? Did this surprise you overnight? Or were there telltale signs that it was going to amount to this? And if there were, tell us the whole process here. Tell us what you guys were thinking. And were you reading between the moves? Were you reading through their moves? Go ahead.
We didn't escalate anymore the remanding of the case to the Supreme Court because we trusted the trial court to do the right thing. We could have had the option of elevating the matter to the Supreme Court, but we said we want this to be done once and for all. At any rate, it appears that the current administration is no longer bent on weaponizing the justice system. There is a stark difference, supposedly, at least in theory, between this administration and the previous administration, at least in terms of weaponizing the justice system. No, so we thought that it might be more prudent to just allow the trial judge to do again what he has already done, and that is to repromulgate the judgment, maybe provide further substantiation as suggested by the Court of Appeals, because we thought that the state will no longer pursue this most expensive frame-up. But apparently we were mistaken because the panel of prosecutors is still there trying to pursue this most unjust case. In fact, in the words of Justice Carpio, the grossest injustice perpetrated before the Filipino people and the entire world. And why is it that the government is still pursuing this? So we were caught off guard that in fact the Department of Justice prosecutors is still filing motions for reconsideration that is in violation of the rules. Ginagawa nilang katawa-tawa yung justice system. Ginagawa nilang katawa-tawa yung most basic rules. Even a first-year law student knows that an acquittal is not subject to a motion for reconsideration. But the state is still pursuing this case and still trying to silence Laila de Lima, who is a duly elected member of the House of Representatives. Again, meron pa silang kinakatakutan kay Laila de Lima. Ang gobyerno ba na ito ay gusto pang patahimbikin si Laila de Lima? Bakit pa nila pinipursue itong business case na to? Tatlong acquittal na ang gusto ba nating mangyari dito? Tatlong acquittal na, pang-apat pa ulit yung repromulgation of the judgment, pang-lima yung sa METC case, cleared of all charges, pinakulong na nila ng 7 taon. Bakit pa ayaw nila tagilan si Laila de Lima?
Here's what they're saying. I'm sorry to cut you there, Attorney De Leon, but this is what they're saying. They're saying, and I'm going to read an excerpt from the MR that was filed, by accepting the subsequent recantation of witness Ragos' hook, line, and sinker, the Honorable Court repudiated all these solemn proceedings without consideration in how the courts and other bodies conducted the proceedings to ensure the voluntariness and veracity of the statements, allegations made by the witness, nor offered an explanation why the statements made by the witness in those proceedings should not be believed and discarded. And then they went on to, it was a matter of the evidence versus the recantation. But before we go into that, let me just get your reaction to what I just read. The court just took it hook, line, and sinker, the witness or the recantation of Ragos without any regard to everything else that happened. They're saying this now when they could have said it before.
Yeah.
A judgment was rendered. Go ahead.
Yeah, Carmina, what are they trying to do? There should be an end to litigation in this country. The justice system could only be stable if there is an end to litigation. No? So the mere fact that they are re-raising arguments time and again, or even novel arguments, new arguments time and again, after already having an acquittal twice, they are trying to, again, roast Laila de Lima because she's a duly elected member of the House of Representatives, maybe because they want her to be silent in her advocacies. So they are becoming successful. If we go line by line in terms of their arguments and try to respond to all of them, no? Why? Because they are successful in getting our airwaves and litigating the matter. But there should already be an end to litigation. But just to answer that, let's remember that Ragos was put on the witness stand twice or thrice actually, almost 12 hours of being in the witness stand after his recantation. And it is not true that his testimony was not corroborated, because the testimony was corroborated by a lot of other witnesses who recanted, including Ronnie Dayan, including even the recantation of Kerwin Espinosa. All of these things are corroboratory evidence because the line is consistent. They were coerced, tinakot sila para mag-recant, no? At yung mga pamilya nila were under threat at that point in time. So it's not true that it was only Ragos, but the mere fact that Ragos was put in the witness stand subject to the cross-examination by this same panel of prosecutors, and then at the same time they even offered a witness, no? A witness to rebut. So tapos na yung presentation ng evidence in chief nila, guys, si Ragos, pinayagan pa ulit sila magkaroon ng rebuttal witness, which is yung PAO officer. Anong sinabi ng judge? Kinote pa yung PAO officer at sinabi mismo na nakatulong pa yung testimony ng PAO officer to say that in fact there was an admission na malakas talaga yung recantation ni Ragos.
So, let me just go back to what you, I'm sorry, Attorney De Leon, let me just go back to what you said a while ago, because that's exactly what they're saying as well, that there was a corroboration by other witnesses on all material points. Tila bagang, itong sinasabi nila, the recantation could not have possibly negated all of these corroboration and all these material points plus the other pieces of evidence. Yun ang isinusulong nila ngayon. Go ahead.
Nakagulat kasi una, hindi to totoo. Pangalawa, ang sinasabi lang nila na corroborate is si Ablen, no? Yung si Ablen supposedly yung nagdala ng pera kasama si Rafael Ragos, no? So si Ablen lang So ngayon, nagre-rely na lang sila sa iisang testimony, no? Ang testimony ni Ablen versus a categorical denial na everything happened versus yung logical incoherence nung nangyari. Ang logical, ang kwento dito sa kasong ito is, nagising na lang daw si Rafael Ragos isang umaga, may tumawag sa cellphone niya, inutusan siyang dalihin yung pera kay Laila de Lima na nakita niya bigla sa higaan niya kasi nandun siya sa quarters. Imagine, the deputy chief and head ng Bucor, deputy chief ng NBI, OIC ng Bucor, nagigising na lang isang umaga, may makita siyang pera, susundin niya yung anonymous phone call at dadalhin niya yung pera kay Laila de Lima. Yun ang kwento na kino-corroborate ni Ablen na sinabi ni Ragos to begin with, hindi totoo. No? So ano yung corroboratory evidence nila? Si Ablen na to begin with, yung kwento hindi totoo. Ang star witness dito, hindi si Ablen, si Ragos. At si Ragos na mismo nagsabi, pinilit siya, hindi totoo lahat, invento ang mga sinabi niya at napuwersa siya dahil tinatakot ang pamilya niya at saka siya. No? So very clear ang recantation and they had the opportunity to already cross-examine them. Pero I just appeal to them, no? There should be an end to litigation. Otherwise, iaakit ulit natin sa Court of Appeals. Papasulat ulit natin sa judge. May motion for reconsideration ulit sila. Fourth jeopardy. Aakit ulit sa Court of Appeals. Papasulat ulit sa judge. Ganun ba ang gusto nating klase dito? Ilang years ang litigation, no? Nawawala ng faith sa justice system kasi these officers of the court are the ones violating their oath, which is why right now we are thinking really of pursuing a case against those people who actually authored this persecution, including these prosecutors who seem to not want to stop persecuting Laila de Lima. Kaya hindi na namin mga signatories.
Okay.
And we're already studying a case for prosecutorial misconduct.
All right, Attorney De Leon, we have a few moments left and we do have to go through some questions still. Let's talk about evidence versus recantation, because this is what the MR is saying. It's saying that there was, as I mentioned a while ago, other pieces of evidence pointing to the role that the congresswoman played in the illegal drug trades in the Bilibid, and that the recantation could not have possibly, as I said a while ago, negated all of these. Your thoughts on that very briefly?
No piece of evidence linked Laila de Lima ever to the drug trade. No. In fact, number one, there is no one has showed that Laila de Lima played a role in the drug trading. That's first. So no evidence whatsoever or ever offered on the drug trading. Number two, there is no money trail. No, ibig sabihin, sinabi mismo ng witness dito sa kasong ito ng Anti-Money Laundering Council, there is no evidence whatsoever linking Laila de Lima to the drug trade and to any piece of flow of money that is illegitimate. That's two. Number three, so walang droga na ipinakita. No? So kung ibig sabihin, kung drug trading case to, anong trade na drugs? Ano lang ang meron? Ang meron ay kaisa-isang testimonya ni Ragos na nagpunta siya kay Laila de Lima para supposedly ibigay yung pera na hindi rin na-establish na nanggaling sa drug trading. So paano naging conspiracy to commit drug trading yung may binigay kang pera na hindi mo alam kung saan nanggaling? Assuming that is true. At best, that is probably graft and corruption, di ba? Pero hindi drug trading. Pero conspiracy to commit drug trading ito, bakit ginawa nilang conspiracy to commit drug trading? Kasi kung corruption, magiging bailable. Pero hindi yun yung intention nila. Ang intention nila, mag-invento ng kaso para patahimikin si Laila de Lima. Hindi sila nag-succeed sa loob ng pulungan. Hindi tumigil si Laila de Lima magsalita at magpasa ng mga batas. Alam na natin lahat ang kwentong yan.
Attorney De Leon, listening to you today, we can go from one spectrum to another. One is that it can be considered incompetence on the part of the state prosecutors. Sinabi mo na rin, paulit-ulit. Kung hindi man paulit-ulit, ngayon lang nila ilalahad. Gayong nagkaroon naman sila ng panahon. Dati you cannot introduce new arguments this late in the game. So that's one. One could probably see it as incompetence. On the other hand, you mentioned the word weaponization. It could be as sinister as that. But from where you sit, is it incompetence? Is it the weaponization as sinister as that? What do you think?
I think it's really weaponization. I don't believe that these prosecutors don't know what they're doing. I don't think I think they've read the same law book that we've read. No, it's a basic doctrine. You cannot appeal an acquittal because of the violation of prescription against double jeopardy. Pero ito na lang sa akin, no. No matter what is your stand, whether you agree with Laila de Lima or not, whether you're a Duterte supporter or not, no, we should all agree that there should be an end to litigation in this country. There could only be a stability of the justice system kung nirerespeto natin yung desisyon ng korte. Hindi yung endless yung ating litigation, endless ang ating persecution. No? So kahit na sino ka pa, kahit na ano pang political affiliation mo, I think we should agree, we should preserve the justice system. And in this particular case, kitang-kita na inaabuso na ang ating justice system, which is why I think liable ang mga prosecutors dito for a possible prosecutorial misconduct.
Attorney Dino De Leon there, legal counsel of Congresswoman ML Party List Representative Laila De Lima. Thanks again for joining us this soon. Appreciate it.
Bunyog, bunyog, halikan na kasama ka. Bunyog, kapag buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw. Bunyog,